video produced for the United States Bankruptcy Court for the District of New Mexico will provide important information for debtors regarding reaffirmation agreements. A reaffirmation agreement is an agreement between the debtor and the creditor to repay a debt that would otherwise be discharged in the bankruptcy. Once you enter into the reaffirmation agreement, it is a legal contract that obligates you for that debt. A reaffirmed debt is not discharged in your bankruptcy case. If you fail to repay that debt, according to the agreement, the creditor can take your property or garnish your wages. If you reaffirm a debt, you are agreeing to pay back the debt under the terms of the reaffirmation agreement. If you discharge the debt, then you are no longer obligated to pay the debt and the creditor can never collect on the debt. Secured debts are handled differently but can still be discharged in bankruptcy. Take, for example, a car loan. A car loan can be discharged in bankruptcy, but the difference is that if the creditor has a security interest or lien against the debt, the bankruptcy discharge does not eliminate the lien on the property. If you are unable to make your payments on the loan, the bankruptcy discharge will not prevent the creditor from taking the car. The bankruptcy discharge will protect you from any action by the creditor to collect on the remainder of the debt. Examples of actions include phone calls, demand letters, or garnishment of your wages. If you fail to make payments as agreed to in the reaffirmation agreement, the creditor may have the right to take the collateral and hold you responsible for any remaining debt on your loan obligation. Any remaining debt on the loan is called a deficiency balance. A deficiency balance is when the proceeds from the sale of the property or the car, in this particular example, are not enough to cover the balance of your loan. You are not required to enter into a reaffirmation agreement with any of your creditors. You should only reaffirm a debt if you believe it is in your best interest. A threshold question is whether you can comfortably afford to make the monthly payments you are agreeing to. The court recommends you speak with an attorney before entering into a reaffirmation agreement in order to protect your legal rights. The judge will determine if a hearing is required for the reaffirmation agreement. If a hearing is set, you will be notified by mail of the date and time. After the hearing, if the judge approves the reaffirmation agreement, an order will be entered granting the reaffirmation. Upon entry of the order, the reaffirmation becomes effective on that day. You must file the proposed reaffirmation agreement with the court before you receive your discharge. If you change your mind and decide you no longer want to reaffirm the debt, you can cancel the agreement. To do so, file a rescission of reaffirmation agreement and notify the creditor. You must cancel the agreement before the bankruptcy court enters your discharge. Important reminders: a reaffirmed debt is not discharged under your bankruptcy. You are obligated to the terms of the reaffirmation agreement after your bankruptcy case is discharged. If you decide to enter into a reaffirmation agreement, you must do so before your bankruptcy case is discharged. If you have general questions about filing reaffirmation agreement or need the necessary forms, you can contact the court's self-help center by phone, online chat, or via email. Keep in mind, the court cannot provide legal advice. You may want to speak to an attorney before entering into a reaffirmation agreement. The court staff can provide you with suggestions for reduced cost legal services. Visit our website at www.nmb.uscourts.gov. The link for the live chat is on our website.